Good day, everyone. My name is Zuko Koza. I'm an attorney at Boto Corporate Attorneys. Welcome to today's session of disciplinary hearing process in the workplace. So, the first question that we have to ask is that what is the basis of the employment relationship? So, the basis of the employment relationship is a reciprocal relationship. What do we mean by saying that it is a reciprocal relationship? It means that the employers will hire employees to provide labor, to produce commodities, and to render their services with the objective of making a profit. Employees will provide their labor and return for remuneration and the opportunity to exercise and improve their marketable skills. So the duties of the employees is thus as follows. It's to enter and to remain in service, to maintain reasonable efficiency, to further the business interests of the employers, to be respectful and obedient, and to refrain from misconduct generally. In turn, the duties of the employers is as follows. To remunerate employees. Obviously, we know that employees cannot work for free. To ensure a safe working environment or conditions within the employment workplace. General contractual duties. When we're talking about general contractual duties, these are benefits that may be included in the employment contracts. Statutory duties, which may include to observe prescribed working hours, to grant leave, to provide certificates of service on termination of the employee's contract, and to also keep prescribed working records. It's important to note that according to employees' various rights, this is in terms of the Basic Conditions of Employment Act as well as the Labor Relations Act. Since we are therefore dealing with the disciplinary hearing process in the workplace, it is very important for us to understand the meaning of dismissal. So obviously, if I had to ask the question to people and say that what does dismissal mean, I'm sure that I'll get a lot of different answers. People may refer to me to the dictionary, Longman or the Oxford Dictionary, but the Labor Relations Act in terms of section 186 actually provides us with a definition of what dismissal is. It's important to note, guys, that it does not only provide us with only one meaning of what dismissal is, but the Act provides us with more than one meaning of what can constitute as dismissals. And I'll just quickly run through the definitions that section 186 provides us with regards to dismissal. So dismissal means that an employer has terminated a contract of the employee with or without notice. It can also mean that an employer reasonably expected the employee to renew a fixed-term contract of employment with the same or similar terms, but the employer offered to renew on less favorable terms or do not renew the employment contract at all. An employer refused to allow an employee to return to work after she took maternity leave. An employer who dismissed a number of employees for the same or similar reasons has offered to reemploy one or more of them, but has refused to reemploy another. An employee terminated a contract of employment with or without notice because the employer made continued work intolerable. So section 186 gave us the meaning of dismissal. So when we move on to section 187, it therefore explains to us when dismissal will be regarded as being automatically unfair. So a dismissal will be regarded as being automatically unfair if the employee has participated in a protected strike, if the employee is basically pregnant or unfair discrimination. So it's important as employers that in this given situation where you're in a working environment where there's trade union activities and that trade union has basically went through the process of the CCMA and they are embarking upon a protected strike, you cannot basically fire employees for embarking upon a protected strike. Remember, we've also said that we cannot fire employees as well for being pregnant or for unfair discrimination. So section 188 basically says to us that a dismissal that is not automatically unfair will be regarded as being automatically unfair if the reason for the dismissal is a fair reason and it's related to the conduct or capacity, it's related to the employer's operational requirements, and that the dismissal was effected in accordance with a fair procedure. It is important to note, guys, that when we are dealing with dismissals, that we also need to take into account the code of good practice, and that in determining whether a dismissal was taken for a fair reason, or whether the dismissal was effected in accordance with a full procedure. The Code of Good Practice has to be taken into account, and this can be found in Schedule 8 of the Labor Relations Act, which is a very important document for employers to basically have in order to guide them with regards to handling labor-related matters, more specifically dismissal matters within their workplace. So one of the key principles of the Code of Good Practice is that employers and employees should treat each other with mutual respect. In the beginning of the slideshow, we said that the basis of the employment relationship is what is a reciprocal relationship. It's a relationship where the employer and the employee basically owe a duty towards each other. It is a relationship where the employee gets into work, they render their services, and in turn the employer will remunerate the employee. It is important that the employee also basically gives good performance to the employer at all times. Employers should adopt a disciplinary code that establishes the standard of conduct required by employees. The form of and content of the rules will vary according to the size and the nature of the employer's business. Larger businesses will require a more formal approach to discipline. So what this means is that if you're an employer and you basically have a large business, it is very important that you have a disciplinary code that is in place that will regulate the conduct of your employees. That disciplinary code also needs to be brought to the attention of the employees so they basically know that if it happens that they find themselves committing any sort of misconduct, they will know of the repercussions, whether it may be a verbal warning, maybe whether it may be a first written warning or final written warning. So in terms of the disciplinary measures that are short of dismissal, so when we're dealing with repeated misconducts, they will generally warrant warnings. So for example, if Sam comes to work and is his first time arriving at work late, so that will warrant, I would say, a verbal warning depending on your disciplinary code. Sam therefore comes to work late again. It can be a written warning. He comes too late again, it can be a final written warning. So remember that you will therefore look at the type of misconduct that the employee is therefore committing, and then based on what the disciplinary code of the company says, if it's a repeated conduct, it can basically warrant warnings. So for most serious infringements or repeated misconduct, may call for final written warning. So depending if, for example, Sam is a person now that has now come to late more than 3 times, you can basically say that, I'm giving you a final written warning. Should this happen again, it's becoming a habit, formal disciplinary proceedings will be taken against you, which can lead to you being summarily dismissed. Also, for matters that we're also looking into that can warrant a summary dismissal or that can warrant a disciplinary proceedings to be taken is if we're dealing with matters that are of severe nature. So we're talking about misconduct such as gross insubordination, gross dishonesty, theft, also misappropriation of company funds. Dismissal should be reserved for cases of serious misconduct or repeated misconduct. In terms of the dismissal for misconduct, it is also important to note that you cannot dismiss an employee for first offense. So if Sam in this given situation had came to work late for the first time, you cannot now therefore just dismiss him for his first offense, except if the misconduct is so serious and is of such a gravity that it makes continued employment intolerable. So in an event where Sam has now committed gross insubordination, or insubordination, now that is where upon a disciplinary inquiry being held, where dismissal, a summary dismissal therefore can be taken against Sam in that given situation. So as employers, so even if you dislike the employee or you have an employee that irritates you because of the color of their hair, but that employee for some reason performs their duties and only arrives at work late for the first time, it doesn't warrant for that employee to be dismissed because it's a first offense. Only in the event that Sam, for example, fails to follow an instruction that is basically given by you, and it's a very important instruction, insubordination or gross insubordination, upon the disciplinary hearings or procedure being taken place, and that can lead to Sam being summarily dismissed. So Section 193 deals with what we call the remedies. So remedies will come into effect when the employee basically decides to take the recommendation of the chairperson to the CCMA on the basis either it was procedurally unfair or substantially unfair. So in the event that it is procedurally unfair, remember with procedural fairness, as we said, we need to look at they look at the fact that the employee has been given a fair chance to basically state their case. They've been given reasonable notice. They are aware of the matter. Even at the disciplinary hearing, they were able basically to also give their version in a procedurally fair manner. If it therefore happens that it goes to the CCMA, and the commissioner finds that, listen, guys, procedurally you are found wanting, the commissioner can either say that a reinstatement can be afforded, or of the employee can be afforded retrospectively to the date of the dismissal. So it will be from the day basically the matter is at the CCMA, where the commissioner says that it was procedurally unfair, to the date of the dismissal. You can also basically have re-employment and then payment of the compensation to the employee of up to equivalent of 12 months or up to equivalent of 24 months for automatically unfair dismissals. So usually with the compensation period, the CCMA usually does not actually give the maximum. It will basically be 3 to 4 months. It seldomly happens that they give the maximum payment of it. As stated, that reinstatement is the primary remedy unless the employee does not wish to be reinstated. The circumstances surrounding the dismissals are such that a continued employment relationship would be intolerable. If it's not reasonably practicable to reinstate or reemploy the employee, the dismissal is unfair only because the employer did not follow a fair procedure. So when it comes to the burden of proof, when it comes to dismissal matters, the principle of he who alleges must prove is not applicable when it comes to labor-related matters. So Section 192 of the Labor Relations Act states that, remember, what has to happen is that the employee has to establish that there is an existence of a dismissal. We've already spoken about Section 186, which gives us a meaning of a dismissal. So the employee will have to say that, establish that, there has been a dismissal. We looked into Section 186, which gives us the meaning of dismissal. The employer will, on the other hand, say that yes, there has been a dismissal, but the dismissal was fair. So it's almost like saying that the employer will have to justify that the dismissal was basically fair. So that is the burden of proof. It's what employee must establish that there has been a dismissal, and the employer must say that yes, there is a dismissal, but the dismissal was fair. So now we are dealing with the disciplinary process, the starting point when you're dealing with the disciplinary process. So employers will usually have initiators. So initiators are the people that will represent the company when it comes to a disciplinary hearing. It is important, I'm going to stress this out, it is important that initiators are well prepared. It is important that initiators gather evidence and represent that evidence in a good manner when it comes to a disciplinary inquiry. So investigation, as I said, the initiators will gather all of the evidence. For example, if we are dealing with an employee that has stolen money from the till, and there was a camera, and then there was another employee that basically saw him stealing that money from the till, the initiator will have to gather that evidence. The initiator will have to get the camera footage proving that employee X has basically stolen the money, and also the witness that was there will have to write a statement, and they'll also have to be present at the hearing. Then it comes to the formulation of the disciplinary charges. Remember, the disciplinary charges basically have to be relevant, So for theft, for example, it will be the disciplinary charges that are relevant that will be for theft will be included. And also, for example, let's say the employee also lied. You can also add dishonesty. So you can add the two relevant charges. It is important to note that when we're doing the charge sheets, we're keeping it relevant. We do not want to stack and just list charges that are not relevant. Suspension pending a hearing, we'll get to the suspension part, but with suspension, it will only be applicable for serious or severe offenses or misconducts that have been basically committed, and also in the event that the employee may hamper the investigation process while they're at work, you may give them a written notice of them being suspended. And then it also comes to the hearing. Remember, when it comes to the hearing phrase, the initiator will basically lead their evidence. So the evidence that they've basically collected from the investigation, it will therefore be tabled at the disciplinary hearing. Remember, the initiator will have to give an opening statement. Once they've basically given an opening statement, I always say that go charge by charge. So if it's theft, you deal with the elements of theft, and then you deal with the elements of the dishonesty. From there, what will therefore happen is that the initiator will be given an opportunity to also to call their witnesses. They'll call their witnesses, introduce their witnesses. If there's any statements that the witness has to read out, the witness basically has to read that statement and say that they are the author of the statement. The employee will be given the opportunity to ask questions or cross-examination. Vice versa will also happen with the employee, in which the employer will be given the opportunity to also cross-examine them, proving allegation of the elements, and then it will be the sanction recommendation. So it's also important that I also want to touch on the fact of the aggravating and mitigating factors. The reason why I want to touch on the factors of the aggravating and mitigating factors is because at times I've chaired disciplinary hearings where the initiator will say that it's a very serious misconduct. However, when it comes to the aggravating factors, they state something totally different. For example, one of the questions that will be asked in the aggravating factors, for example, has the trust relationship been broken? I had one where the employee, basically the initiator, said that no, the trust hasn't broken, but the person has committed theft. It is very important that with the aggravating factors, and the question that normally comes out is basically whether the trust relationship has been broken and whether it can be repaired, whether the employee basically has previous disciplinary records, and what is the precedent that has been set by the company, whether the company suffered any financial loss. Those are the few questions that are basically asked when it comes to the aggravating factors, and also the impact on the relationship of trust, which is very important. So it's important that initiators ensure that they understand those questions that are basically asked, especially when it also comes to the aggravating factors. One of the important things as well is also for the initiator to understand evidence that is basically being laid. Remember, we've got real evidence refers to an object which can be examined. For example, if we have a knife, for example, that was used, I know that it is too much of a serious example, but if it's a knife that has been used, that will be constituted as real evidence. And then we've got direct evidence is given by a person at the hearing. I saw John stealing the money. Documentary evidence, remember, we're relating to emails or affidavits. So remember, we had the example of the cashier that stole money, and then there was a witness. The witness can basically also give an affidavit in which they're basically going to have to read that affidavit read that affidavit and say that they're the author of that document. Hearsay evidence is inadmissible evidence. Remember, this is evidence where someone heard or heard someone saying something, you're recounting what another person had heard. It is inadmissible evidence. And then we have circumstantial evidence requires a decision maker to draw as an inference from a chain of events. Each fact relied upon to form the link needs to be proved. Circumstantial evidence should be treated with caution. It's also very important to note that when formulating the evidence and when we're drafting the charge sheets, that everything is clear. I always say that, remember that the employee is also going to be receiving this charge sheet. So if it's gross dishonesty, you're going to state that gross dishonesty in that on the 23rd of April 2019, you had lied about reporting to work and filling in the register. that is just an example, but it has to be clear. Remember, it's got the dates, when it happened, and what happened. Gross insubordination in that you failed and or refused to comply with a reasonable or lawful instruction that was given to you by your manager on the 29th of January 2019, in which you were instructed to go and pick up a load, which you refused to do so. Remember, it's got the dates, it is clear, it states what the employee had basically done. So you need to ensure that when you're formulating the evidence, it is clear and concise, and that you're just not formulating evidence for the sake of formulating it, or formulating evidence where as well the employee cannot basically do their own preparation for the hearing. So remember that once the charges have been formulated, the employee will have to be notified of the hearing date. Remember, 48 hours must be given, guys. It's very important that you do not give them less than 48 hours, but they have to be given 48 hours. So the details of the hearing and where. So when we're talking about the details of the hearing, it must state the name of the employee, when the hearing will take place, and where the hearing will take place. Will the hearing take place within the offices, at the offices of the employer? The allegations, remember the allegations are important, where we stated that the allegations need to be clear, they need to have the date, they need to state what the employee is being charged for. The rights afforded to the employee. It's very important that in your disciplinary notice, the rights of the employee are listed. Remember, reasonable notice of the hearing, to call witnesses, to state their case in response. They can call an interpreter and a representative, a fellow trade union person, or an employee. Identify identity of the person issuing the notice, so whoever will be issuing the notice, and acknowledgement and receipt of the notice. We also stated that when it comes to suspensions, with the suspensions part, we said that suspensions will only take place for only severe allegations or only severe matters. So if you feel that the person has been charged with, for example, theft, or they've been charged with a very severe misconduct, and that they may hamper or intimidate the witnesses, you can basically proceed to suspend the person. Remember, a written notice will also have to be given for the suspension as well, of the employee. So it's very important to note that once the initiator has basically formulated their evidence, as I highlighted previously, is that when it comes to the disciplinary hearing, they need to summarize the facts and the supporting allegations. So they need to summarize what basically happened. They do not have to give a 3-page or 4-page opening statement. I've had disciplinary hearings where initiators will give 4 pages, which is not necessary. So just a summary of what happened, and what brings us to the hearing. You need to identify the witness and summarize the relevance of the witness. So for example, I'll be calling John, as he was the person that was present when X had basically stolen the money. So John will therefore come up as well. And then you need to submit an argument in the conclusions that should be drawn by the chairperson and the appropriate section that is sought. So it's also important to note that the employer bears the onus to prove that the charge on a balance of probabilities. The initiator presents evidence by leading evidence of witnesses. Lead evidence in a chronological sequence for each charge. Remember, as I said, that if there's 3 charges, don't just speak as the initiator. State charge 1 and then speak on that charge. So it needs to be chronological, meaning that it needs to be easy for the person to basically to follow as well. So lead evidence means to adduce facts from one's own witness. Lead evidence on an impact on the relationship of trust. So remember, that is often when the aggravating fact, that's a question that will come up a lot in the aggravating factors, when the aggravating factors are asked. If they ask, has the trust relationship been broken? The basic rule of leading evidence are: ask open-ended questions. Leading questions are generally prohibited, and documentary evidence must be adduced and authenticated or explained. As we stated that, remember, the employee and the employer will be given an opportunity to both cross-examine each other. Remember, the basic rules are that we do not cross-examine crossly, adhere to the purpose of the cross-examination, that is, to elicit concessions and admissions or issue of facts or law, to challenge facts and documents in dispute, to put a version or supposition to a witness. I put it to you that you stole the money, or I put it to you that you were present when the money was stolen, highlights inconsistencies. So it's also important that the initiator also prepares a closing argument. Remember, guys, the purpose of the closing argument is not to persuade the chairperson to, to accept your version. Remember, it's on a balance of probabilities, which version is much more probable. You summarize the employer's case, you highlight inconsistencies and improbabilities in employee's version, argue why employer's witnesses are more reliable and credible. You deal with the gravity of the misconduct, which reference to the disciplinary code. It's very important. The gravity of the misconduct, you'll say that this is such a severe misconduct, and that also, the precedent that is set by the company, that is one thing that will come in, in the aggravating factors, the circumstances surrounding the infringement, aggravating factors, lack of remorse, and willfulness as well, and impact on the relationship of trust, operational risks. Thank you so much, guys, for tuning in this session. This brings us to the end of it. Should you have any further questions, please contact me on 011-867-0119 or email at legal@botocopo.co.za. Please also note that should you need assistance with disciplinary hearings, drafting of employment contracts or policies, we render those services to our clients. So anything that you need regarding labor related issues, we are here for you and will provide our service for you. Thank you so much.